Okay, welcome to the first video for week 13. Um, Lainey is here. She just as I started this video, she decided to start misbehaving, so here we go. All right. We have to finish up one more issue with state power to regulate before we move on to what I've characterized in prior videos as more interesting topics. But the one thing that we still have to talk about when it comes to state power, so remember how the course is organized, right? Can the government do that? That's constitutional law. The answer to that depends on which government you're talking about, right? Because there are different principles and different tests that apply to each type of government, whether it's federal judicial, federal legislative, federal executive, or state. We've moved to state. All we've got left then is to talk, after we get done with the power of the state and limits on the power of the state, all we got left is to talk a little bit about procedural due process and the state action requirement, right? And then the rest of our time for the Lainey, for the next couple weeks, will be taken up doing review and exercises. Okay, one limit. So we've talked about the scope of state power, right? The 10th Amendment, the police power, right? That's the scope of state power. Some of the limits on state power would be dormant commerce principles, the Privileges and Immunities Clause of Article 4. Lainey, seriously? And then I know a lot of limits that we'll talk about in common law too, right? Interfering with individual rights, violating the Equal Protection Clause and things like that, First Amendment, and other issues. But another limit that we have to cover in Con Law 1 is the Contracts Clause. Now, as you obviously know, right, Article 1, Section 8. So Section 8 of Article 1 tells Congress what it's allowed to do, right? It's enumerated powers. But in the same article, Article 1, when we've talked about the history here, the idea behind the Constitution was to take a significant amount of the power that had previously belonged to states, right, and transfer that power to a federal national government, a central government. So not only does Article 1 tell Congress what it is allowed to do, there's also a section in Article 1 that specifies things that states are not allowed to do. And that is Section 10, not Section 8, right? Section 8 gives Congress its power. Section 10 tells states some of the things they're not allowed to do. Let me read it to you. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, not allowed to coin their own money, emit bills of credit, make anything but gold or silver coin, a tender, a payment for debts. That's a little bit old-fashioned, obviously. Pass any bill of attainder, ex post facto law, or law, here we go, or law impairing the obligation of contracts, or grant any title of nobility. So, there's a lot going on there, but we've talked about this, right? States are not allowed to have their own treaties, coin their own money, all stuff that they were doing before the Constitution, right, under the Articles of Confederation. So, we want to focus in here on the obligation of contracts part, right? This is called the Contracts Clause, and that is one of the limits, right, on a state powers to act. A state is not allowed to impair obligations of contracts. Sound that out. Right? Obligations of contracts. Well, that means, right, the terms of a contract, right? Something somebody is required to do under a contract as an obligation. Why have a clause like this? Well, because again, before the Constitution was adopted, there was a history of states messing around with contractual obligations, and especially their own, right? Wouldn't that be nice to be able to just cancel your own contract obligations whenever you want to? So the Constitution specifies that states are not allowed to do that. Now I want to talk at a practical level here about how the Contracts Clause works. Contracts Clause, there wasn't a lot of litigation about it until and by the way, the litigation that has arisen in recent years, and when I say recent years, I mean the past 10 to 15 years, has been mostly at the lower courts. But again, anytime that stuff starts to percolate up into the court system, the bar examiners look at that and say, okay, there's fodder for more questions. So let me give you a couple examples of how a contracts clause violation might work, right? Or look, I should say, right, just for issue spotting wise. But first, let's talk about what the rules are. Number one, let me repeat, this only applies to states, right? This contracts clause, it says states, no state shall, right? So states are the target of this. So don't take the bait, rather, when you see a fact pattern where Congress is interfering with the obligations of contracts, right? Congress is not subject to the contracts clause, states are. So you need a state, and obviously that includes subdivisions of states, right? So if you're a county or a city, right, municipality, same rules apply, public school district, etc. So the contracts clause only applies to states. You can think of this as elements, right? You need to have a state. If there's not a state or subdivision of a state in the fact pattern, there's no contracts clause violation. Okay. The second element you need for a contracts clause violation, right, to happen, would be for states interfering in pre-existing contracts. So let's be clear about this, right? States are allowed to regulate prospectively, right, and regulate how contracts are going to be formed in that state from now on. They're not supposed to be messing around with pre-existing contracts, right? Because an obligation under a contract, and that's what the clause says, an obligation under a contract only arises if the contract has been executed and is in place. And you studied all that in contracts, right? So you need a state and you need a pre-existing contractual obligation. So again, don't take the bait when you see a state regulating, right, how contracts are going to be executed in the state, right, or what contracts are legal in the state, right, from now on. That is a completely different matter. Contracts clause does not apply to that. Third, and this will bring it back to contracts a little bit, and I can't remember now if it's, there's the case about the Barron cow. I don't know if it was that the Rosda cow case. I don't know, it's been a while. But, you know, contracts have a lot of different terms to them, right? And some of them are important and some of them are not. Some of them are minor, and, right, the kinds of terms that people would enter into a contract with or without those minor terms. So what we're talking about here is material terms of a contract. So now we're up to three things, right? A state is not allowed to interfere with pre-existing contracts, but, you know, as to those pre-existing contracts, we're talking about the material terms of those contracts. So three things you're looking for in a fact pattern before you have a contracts clause violation. There's a state doing it, there is a pre-existing contract, right, and the terms that have been changed, right, the terms that the state have changed are the material terms, or are material terms of the contract. So, you know, if you think you're buying a fertile cow but it's a barren cow, or the other way around, right, then that's a material term of a contract. So, a couple of examples. I am taking these from fact patterns that developed in Michigan while I was still up there. In one case, some of you might have heard of this, the governor decided that some cities were being run poorly, right, and being mismanaged financially. And under Michigan state law, the governor is allowed to appoint something called an emergency financial manager, right, to go basically take over the city and become the god of the city. Okay. The governor declared several cities to be in a financial emergency, appointed emergency financial managers, dispatched those managers, they're called EFMs, right, to the cities that they're supposed to take over, and those emergency financial managers set about quite quickly canceling contracts, right, that the city had already executed with contractors, right, to do construction projects and things like that. Let me run you through our three elements. Is Michigan a state? Answer, yes. Okay, are these pre-existing contracts? Answer, yes, as the facts as I just described them, right? They're contracts that had already been executed between cities and construction companies. Those are pre-existing contracts. And now you get to the third one. Well, did they interfere with material terms of the contract? Well, they canceled the contract, right? And obviously, if you cancel the contract, you've interfered with every term of the contract, including the material terms. Another example up from Michigan. Michigan, when I was up there, adopted, this was in around 2004, was part of a massive nationwide effort to target LGBTQ Americans for political purposes. and there was a referendum. We know what that is, right? A referendum. We've talked about those. Referendum initiative, ballot question in Michigan, which went further than ballot questions in other states, saying that the state of Michigan could only recognize the union of one man and one woman, right, as a marriage or for any other purpose, right? That language is so broad that state universities, right, got in some hot water because they were before that amendment was passed, right, via this ballot initiative. State universities were giving same-sex medical benefits, right, to same-sex partners in home, I believe, same-sex partners of their employees. So along comes the state of Michigan. Again, is that a state? Yes, it's a state. Okay, and there are these pre-existing contracts? Yes, these are already employees of state universities and they already have employment contracts, right? And are these material terms of the contracts? I don't know about you, right? But when you talk about medical benefits, right, and who's covered and what's covered, I always joke when I cover this material, I love my job. I love what I do for a living. But if I went, if I checked my laptop and had an email in my inbox saying that my health insurance was heretofore canceled, you would not see another video from me. Okay, I don't know who would be doing this, but it wouldn't be me because I'm not working, right, without health insurance. That's part of the bargain here. And what I'm getting at is that a material term of the contract? You bet it's a material term of the contract, right? So fact patterns like that sort of got the contracts clause back in, right, the picture and back in front of mind for bar examiners. So you do have to know those, right, those rules. I sense that I'm going a little longer on this video. I don't want to push up against my 15-minute YouTube limit. So I'm going to end this video right now and then finish the contracts clause with a brief discussion of when is it okay for a state to interfere with material terms of a contract. Of course, you know, what good is a rule without an exception, right? It wouldn't be any fun. So hang on, and I'll be posting a second video to finish up the contracts clause.